In the previous chapters, we explored the closing process, the handling of costs, prorations, and financial adjustments, all of which prepare the transaction for its final step, the disbursement of funds and the transfer of title. The seamless coordination of these steps depends heavily on one central figure, the escrow officer. Escrow officers play a vital role in ensuring that all contractual and legal obligations are fulfilled before property ownership changes hands. Their work upholds the principles of fairness, accuracy, and neutrality in real estate transactions. In this section, we identify the statutory duties of an escrow officer in Arizona and examine how those duties align with the broader framework of Arizona real estate law, ethical practice, and consumer protection. Definition and purpose of escrow. Escrow is a neutral process in which an impartial third party, usually a licensed escrow officer or title company, holds and disperses funds and documents according to the terms of a written agreement between a buyer and seller. The purpose of escrow is to protect both parties by ensuring that no funds or legal documents are released until all conditions of the sale have been met. The escrow process safeguards against premature transfer of money or title, creating a system of accountability that benefits every participant in the transaction. Arizona law under ARS Paragraph 6 et seq. Governs the operation of escrow agents and requires them to be licensed through the Arizona Department of Financial Institutions, AZDFI. This licensing ensures that escrow officers are qualified, properly bonded, and operate under strict regulatory oversight. Their duties are distinct from those of real estate licensees, but complement the broker's role in managing the transaction. The escrow officer serves as a fiduciary to both the buyer and the seller, meaning they must act with the utmost integrity, honesty, and impartiality at all times. Statutory duties of escrow officers. The statutory duties of escrow officers in Arizona are clearly defined by both state law and administrative rule. They are responsible for receiving earnest money deposits, holding documents such as deeds, loan payoffs, and releases, verifying title conditions, preparing settlement statements, and ensuring all funds are dispersed only after all contract terms have been satisfied. Each of these duties must be performed with strict accuracy and neutrality. Escrow officers must follow written escrow instructions, which outline the specific steps to be taken before closing. These instructions are signed by both parties and can only be modified by mutual written consent. Once funds and documents are deposited into escrow, the officer assumes full responsibility for ensuring compliance with those instructions. For instance, an escrow officer cannot release the buyer's funds to the seller until the deed is properly executed and ready for recordation. Any deviation from these instructions could constitute a breach of fiduciary duty and subject the officer or company to disciplinary action. One of the most important statutory duties is the handling of trust funds. Similar to how brokers must maintain a trust account under ARS, Paragraph 32 through 2151. Escrow officers must also hold all monies in a separate fiduciary account. These funds are not the property of the escrow company, but belong to the parties in the transaction until disbursement is authorized. Mismanagement of trust funds, such as commingling client money with company funds or unauthorized disbursement, is considered a serious violation and may result in criminal penalties under Arizona law. Neutrality and fiduciary responsibility. An escrow officer's neutrality is fundamental. They do not advocate for either party, but instead ensure that the transaction complies with all legal and contractual requirements. Arizona courts have consistently reinforced the duty of impartiality and proper conduct. In Burcons v. Tycor Title Insurance Commerce of California, 1991, the Arizona Supreme Court held that escrow agents owe fiduciary duties to all parties to act honestly, disclose material facts within their knowledge, and follow instructions precisely. The court emphasized that when an escrow agent deviates from these duties, they may be held liable for resulting damages. Another case, Tucson Title Insurance Code v. D'Ascoli, 1961, further established that escrow officers are trustees of the funds they hold and must release those funds only under the exact terms of the escrow agreement. This case also made clear that escrow officers may not take direction from one party alone, even if that party appears to be in control of the funds. Such neutrality preserves trust in the system and ensures equitable treatment of both buyer and seller. The role of escrow in risk reduction. The escrow process reduces risk by ensuring that all parties perform their obligations before closing. For example, the buyer must deposit the purchase funds. The lender must provide loan proceeds. The seller must deliver a properly executed deed, and the title company must confirm clear title. Only when all these conditions are met does the escrow officer record the deed and release the funds. This sequence prevents premature ownership transfer or payment in the event of default. Escrow officers also handle legal documentation, such as the affidavit of property value, the warranty deed, and the deed of trust, ensuring each is properly signed, notarized, and recorded. They prepare the settlement statement, balancing credits and debits between buyer and seller, verifying that lender and commission payments are correct, and ensuring that property taxes are paid and prorated. In this role, the escrow officer functions as both an accountant and a compliance officer, ensuring that every part of the transaction is documented in accordance with Arizona law. Their work must adhere to both statutory obligations and the broader duty of good faith and fair dealing, a legal doctrine recognized in Arizona contract law that applies equally to escrow. Discussion. Why must escrow officers remain neutral in the performance of their duties? Answer. Because they represent both parties equally and must ensure that all contractual conditions are met before dispersing funds or documents, maintaining fairness and trust in the transaction. What are the statutory responsibilities of an escrow officer regarding funds held in trust? Answer. Escrow officers must maintain all funds in a separate trust account, disperse them only as instructed in writing, and ensure that all payments and documentation comply with the terms of the escrow agreement. How does the case of Burkons versus Ticor Title Insurance Co. reinforce the fiduciary duties of escrow officers? Answer. It established that escrow officers owe fiduciary duties of honesty, disclosure, and strict adherence to escrow instructions, and may be held liable if they breach those duties. Review summary. Escrow officers occupy one of the most critical positions in the real estate transaction process. They act as neutral fiduciaries, ensuring that all contractual and statutory obligations are met before the transfer of ownership and funds. Their duties include receiving and safeguarding trust funds, managing closing documentation, preparing settlement statements, and ensuring that the transaction is recorded properly with the county. Arizona statutes and case law, such as Burkons vs. Ticor Title and Tucson Title Insurance Co. vs. D'Ascoli, reinforce the principle that escrow officers must act impartially, honestly, and with precision. Their neutrality and attention to detail protect all parties from risk, promote legal compliance, and uphold the integrity of the closing process.